So the claimant commenced this suit by way of complaint and other accompanying processes filed on the 18th of January 2021 and asked for the following reliefs against as contained in the statement of facts against the defendant. Number one, declaration that by virtue of the express provision of clauses 11.9, 11.3, 11.8, 11.9, 11.4.7, 11.4.9, and 11.4.12 of the Dependent Company Staff Handbook, all disciplinary processes leading to the dismissal must undergo a formal disciplinary hearing stroke inquiry via a duly constituted disciplinary panel of the company. Number two, a declaration that the summary dismissal of the claimant by the defendant is wrongful for want of setting up of a formal disciplinary hearing stroke inquiry to look into the allegations against the claimant contrary to the express and mandatory provisions of the defendant's employee handbook. Number three, a declaration that the summary dismissal of the claimant by the defendant is premeditated and same amounts to unfair labor practice. Number four, a declaration that the outcome of the wrongful and ill-fated disciplinary process against the claimant is perverse, unreasonable, and unfair, having regards to the defense put off, by the claimant. Number five, a declaration that the manner, approach, and circumstances surrounding the summary dismissal of the claimant from the service of the defendant is demeaning, having regards to her status as senior manager of over 20 years meritorious service, and same amount to a grave breach of the claimant's fundamental human right to dignity of human person guaranteed by the Constitution of the Federal Republic of Nigeria, 1999. Number six, damages in the sum of 103,607,199.92 naira only against the defendant, representing the claimant's 3 years annual gross salaries in damages for wrongful dismissal. Or in the alternative, an order of court directing the defendant to pay the claimant the sum of 60,437,528 naira 4 kobo only as redundancy pay. An order of the court directing the defendant to pay the claimant the sum of 2,877,978 naira only being the 1 month payment in lieu of notice due to the claimant as per her contract of employment and the company's staff handbook in the event of termination or redundancy. Damages in the sum of 34,535,526 naira only against the defendant representing the claimant's 1 year annual gross salary in damages for unfair labor practice meted to the claimant. Number 10, damages in the sum of 34,535,730,526 naira only against the defendant representing the claimant's 1 year annual gross salary. Being damaged for breach of the claimant's fundamental human right to dignity of human person guaranteed by the Constitution of the Federal Republic of Nigeria. Number 11, 2 million naira only being cost of this suit. Number 12, 21% interest or relief 6 7, 8, 9, and 10 from the date of judgment till when judgment is fully paid. The defendant, in reaction to the claimant's suit, entered appearance and filed his statement of defense on the 1st of March 2021 by leave of court granted on the 17th of March 2021. Meanwhile, the claimant also filed a reply to the defendant's statement of defense on the 17th of June 2021, which was deemed as properly filed and served on the 21st of June 2021 following an application for leave to that effect. Case of the claimant. From the pleadings filed by the claimant and her testimony, she was employed by the defendant in 1999 and had been in said employment until when she was wrongfully dismissed on 2nd December 2020. It was survived by the claimant that the defendant company, as a result of some ongoing financial challenges, was bought over and a new management took over the company, and since the takeover, several unfair labor practices characterized the affairs of the defendant. The claimant was issued queries by the defendant, which she responded and cleared herself of the allegations in the said queries. That despite the claimant's response and without any formal disciplinary hearing whatsoever, she was dismissed summarily on the 2nd of December 2020 on the ground that her responses to the queries were unsatisfactory. It is the claimant's case that her dismissal was wrongful on account of breach of fair hearing, among other reasons. That the claimant stated that her dismissal was a ploy by the defendant to avoid redundancy and attendant redundancy pay that would be due to her. That the redundancy became very imminent and unavoidable on the sale and takeover of the defendant by a new management. According to the claimant, she was never at any point given an invitation to any disciplinary hearing, neither did she attend one. Case of the defendant. The defendant case is that the claimant was not dismissed as a result of any vindictiveness or unfair labor practices as alleged. The defendant contends that the claimant was dismissed following an outcome of disciplinary hearing set up to consider the allegations leveled against her as contained in the defendant queries and the claimant's responses in relation thereto. Allegations bordered on, number 1, breach of the defendant's policies, number 2, negligence in the performance of the claimant's duties, and number 3, disclosure of the defendant's confidential information or document without approval. The defendant contends that the disciplinary inquiry set up to consider the allegations was in accordance with the provisions of its staff handbook and disciplinary policies and procedures. According to the defendant, the disciplinary inquiry complied with the rules of procedural fairness and afforded the claimant the opportunity to be heard before the decision was reached. The disciplinary inquiry found that the claimant failed in her duty to raise the issue of inadequate notice periods given by 2 former employees to the defendant contrary to the provision of staff handbook and their non-compliance with the defendant's leave policy. To survive by the defendant that the claimant was also found negligent in disclosing the defendant's confidential payroll file and information without approval. The defendant maintains that it's not liable in any way to the claimant for the sums claimed or at all for the declaratory reliefs sought. The defendant further states that the claimant's claims are frivolous and vexatious, as the relief sought are baseless gold digging voyage. The defendant further states that the claim was not and could not have been declared redundant as alleged. Trial commenced on the 21st of June 2021, while the claimant testified by adopting a witness statement on off the 18th of January 2021 and 17th June 2021 and tendered the following documents as exhibits. Exhibit JM1, JM2, 3, 4, JM 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, JM 21, 22, 23, 24, 25, 20, and 26. Claimant was thereafter cross-examined by the learned counsel to the defendant on the 26th of October 2021, and the following documents were tendered by the defendant during cross-examination. Exhibit JM 30 and JM 31. The case of the claimant was then closed as there was no re-examination. The defendant opened his case by calling his sole witness one, Adeola Olabi, who adopted her witness statement on oath dated 1st of March 2021 and tendered the following documents as exhibits. Exhibit INQ 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12. The defendant DW1 was thereafter cross-examined by counsel for the claimant, and as there was no re-examination, the case of the defendant was closed, and the matter was adjourned for adoption of final written addresses. Defendant's final written address dated 16th November 2021 was filed on the 19th November, wherein one issue for determination was submitted to it, and I quote, "Further, from the fact and circumstances of this case and the evidence adduced, the claimant is entitled to the reliefs sought," unquote. Counsel to the defendant submitted that the burden of proof lies on the claimant to demonstrate by credible evidence that she is entitled to the reliefs on the complaint and statement of facts. It was further submitted that the claimant's allegation that her dismissal was wrongful for want of setting up of a formal disciplinary inquiry to look into the allegations against her was unfounded. Counsel relied on clause 11.13.1 of the defendant's staff handbook, exhibit INQ3, and disciplinary policy and procedure, exhibit 7, exhibit INQ9, to submit that the outcome of the disciplinary process is not reasonable or unfair. The dismissal was not premeditated, nor amounts to unfair labor practice. It was submitted by the defendant that the claimant did not deny any of the allegations against her for negligence in the performance of her duties and for breach of the defendant's policy. And the counsel for the defendant submitted that the claimant was afforded an opportunity to be heard and was indeed heard, having responded to the queries and provided clarifications, albeit unsatisfactory responses at the disciplinary hearing. The claimant's dismissal was neither wrongful nor the decision reached after the disciplinary hearing unreasonable or premeditated. The claimant's position was not declared redundant, and as such, the claimant is not entitled to the sum claimed as redundancy pay. It is the counsel's submission that, notwithstanding that the claimant was dismissed for negligence in the performance of her duty and breach of the defendant's policies and rules, the defendant made an ex gratia payment of 2,366,105 naira 32 kobo only to the claimant after she was dismissed, even though the claimant was not entitled to any benefit as held by the court in several decisions. Claimant's final written address. Claimant's final written address, which is dated and filed on the 14th of February 2022, was deemed as properly filed and served via leave of court. The final written address contains 5 issues for determination to it. Number 1, whether the defendant truly set up a disciplinary panel for the claimant in view of the totality of the evidence before the court. Number 2, without prejudice to issue 1, whether the composition of the purported disciplinary panel is not in violation of one of the twin pillars of fair hearing, or rules of natural justice, namely, nemo judex in causa sua, you cannot be a judge in your own case. Without prejudice to one, to issue one, whether the purported disciplinary committee was properly and validly constituted with regards membership of the panel, qualification including attendance by relevant officers of the defendant. Without the manner and circumstances relating to the dismissal of the claimant, including the composition of the purported disciplinary panel, is not a violation of the claimant's fundamental human right to dignity of a human person guaranteed by the Constitution of the Federal Republic of Nigeria. Number 5, whether the claimant has proved her case to be entitled to the reliefs sought. The submission of a counsel that issue 1 can be determined upon the consideration of exhibits JM8 and INQ8, clauses 11.9.1 and 11.3.9. Another counsel submitted that for the defendant to establish before this court that disciplinary proceeding indeed took place, the claimant in attendance has tried to do as it has tried to do, same must be done with production of credible, crucial, and substantial evidence, one of which is the invitation letter to the disciplinary hearing, which must be served on the claimant as provided for in clause 11.3.9 of exhibit JM8. Counsel submitted that in the instance case the defendant failed to provide any of these documents before the court, as the documents do not exist. And there was no invitation to the disciplinary hearing that was extended to the claimant, and the claimant attended no disciplinary hearing before she was dismissed by the defendant. Counsel submitted that the purported disciplinary process leading to the dismissal of the claimant was concluded in less than 24 hours. The claimant responded to the query issued to her on 1st of December 2020 and was subsequently removed the next day. The defendant, in a bid to establish before the court that it concluded a disciplinary hearing before dismissing the claimant, concocted and came up with exhibit INQ, purported minutes of disciplinary hearing dated 2nd December 2020, the same day she was dismissed. The content of exhibit 2 only made reference to the query issued to the claimant, but no reference to the purported disciplinary hearing was made in exhibit JM2. That exhibit INQ8 reveals that the purported disciplinary hearing commenced at 5:21 p.m. on the 2nd of December 2021 and was not signed by the claimant, which is against the customary practice that the minutes of a disciplinary hearing are signed by the accused employee as well, even though the accused may refuse to sign. That the minutes of the disciplinary hearing are signed by the accused employee as well, even though the accused may refuse to sign. Counsel submitted on issue 2 that, assuming without considering that the defendant actually set up a purported disciplinary panel, purported panel was in gross violation of one of the 2 pillars of fair hearing and natural justice, which is expressed in the Latin maxim, nemo judex in causa sua, which means you cannot be a judge in your own case. Section 36 of the Constitution of the Federal Republic of Nigeria 1999 was cited in 8. The disciplinary proceedings carried out in breach of the rules of fair hearing and natural justice is null and void and should be set aside, citing the case of Yaro and Nigerian Stock Exchange. And the counsel submitted on issue 3 that the purported disciplinary hearing runs foul of the express provision of exhibit JM8 as regards the membership of the disciplinary panel. That clause 11 of exhibit JM8 provides that, and I quote, "It is the responsibility of the HR and the legal office to appoint an executive head stroke senior manager to chair the disciplinary inquiry," unquote. However, Exhibit INQ8 shows that the purported disciplinary committee was chaired by the managing director of the company, as again the express provision of clause 11.3.8 of Exhibit JM8. According to the claimant, the defendant's sole witness under cross-examination confirmed the fact that the managing director was the chairman of the panel. And accounts submitted that it is the case of the claimant that there was never a disciplinary hearing, and if at all there was, as alleged by the defendant, she was never afforded reasonable time. She was never afforded reasonable time to prepare her defense before the purported disciplinary hearing. Counsel referred to clause 11.4.9 of Exhibit 8 at page 23. The claimant only had a few hours to prepare her defense against the minimum notice of 5 days provided in the handbook. Counsel further submitted that the allegation leading to the dismissal of the claimant, as stated in the queries issued to her, was born out of the resignation of one Tope Oresilu, who resigned from the service of the defendant in November 2020. That the grounds of the defendant is that the said Tope didn't give sufficient notice of resignation in line with Exhibit 8, and that she also converted unused leave days as part of her resignation notice. That the claimant responded to the query issued to her, wherein she gave soothing explanation in defense of Exhibit JM3. Nevertheless, the defendant went ahead to dismiss the claimant from his employment. Another counsel submitted on issue 4 that the treatment of the claimant is demeaning, degrading, and inhuman, and in grave breach of the claimant's fundamental rights to dignity, fundamental rights to dignity of human person guaranteed by 1999 Constitution. The defendant treated the claimant in the most degrading manner by giving her junior the authority to issue her query, and also sat as a committee member in the purported disciplinary hearing that dismissed the claimant. Counsel submitted on issue 5 that the claimant's primary relief touches on the wrongful dismissal as contained in the general form of complaint and statement of facts, that where there is a laid down procedure to be followed in dismissing a staff, the procedure must be strictly complied with, otherwise the dismissal becomes wrongful, as it is in this case. But it is strict law that staff handbook is binding on the parties to a contract of employment. But the claimant dismissal is therefore wrongful. Another counsel submitted that the quantum of damages to be awarded by the court in wrongful dismissal is at discretion of the court. That the claimant has prayed to this court for 3 years' gross salaries as damages for wrongful dismissal. That by the provision of the claimant's contract of employment, Exhibit 1, he is entitled to 3 months' notice of contamination, or according to the counsel, 3 months' salary in lieu. Counsel submitted that the claimant had demonstrated in paragraphs 12 to 19 of assessment of fact that the defendant sacked her to avoid payment of redundancy pay. That clause 19 of Exhibit 8 provides that in the event that the company is unable to further provide employment, the company shall give 1 month notice of same, including a redundancy pay computed at the rate of 1 month's salary for every computed year worked. Defendant also filed a reply on points of law to the claimant's final written address on 2nd of February 2022. Court's decision. Upon careful perusal of the pleadings filed by the parties, the evidence adduced, and the submissions of the respective counsel, I note that the defendant in his submission formulated 1 issue for termination and the claimant formulated 5. But the short point upon which I will decide this case as submitted by the defendant is, I quote, whether from the facts and circumstances of this case and the evidence adduced, the claimant is entitled to the reliefs sought, unquote. The grounds of the claimant against the defendant from the avowed fact in her pleadings is that she took up employment with the defendant in 1999 and had been in the said employment until when she was wrongfully dismissed on 2nd December 2020 without being given a hearing. Claimants avowed that since when the defendant was bought over as a result of financial challenges and a new management took over, several unfair labor practices characterized the affairs of the defendant. It was stated by the claimant that she was issued query by the defendant and responded to same and cleared herself of the allegations in the said query. But despite the claimant's response and without any formal disciplinary hearing whatsoever, she was dismissed summarily on 2nd December 2020 on the ground that her response to the query was unsatisfactory. It is the claimant's case that her dismissal was wrongful on account of breach of fair hearing, among other grounds. It is a further grievance that she was never at any point given an invitation to any disciplinary hearing, neither did she attend one. Now, the entire hurried process of issuing a dismissal letter to the claimant less than 24 hours of her response to the query in order to summarily dismiss her is a grave breach of the defendant's disciplinary procedure as contained in his handbook. It clearly shows a premeditated intention to kick out the claimant unceremoniously. The claimant in the alternative state that her dismissal was a ploy by the defendant to avoid redundancy and the attendant redundancy pay that will be due to her. In proof of the alleged wrongful dismissal, the claimant in the instance case owes the tax to plead the terms and conditions of her employment and to show how they have been breached and who has breached same. See the case of Ido, Niboy, and NNPC, Madaru Tumba, and Waju and Abdurrahim. Claimant in her bid to found her claim with a view to discharging the burden she bears, presented among others her offer of employment and staff handbook, Exhibit JM1 and 8. It is pertinent to observe that in determining the key reliefs raised by the claimant that all disciplinary processes leading to her dismissal must undergo a formal hearing and that her dismissal is wrongful for want of that disciplinary hearing, recourse shall be had to Exhibit JM8. Now, let me quickly refer to clause 11 of Exhibit JM8 as follows. Article 11.3.1. Disciplinary action must be lawful, fair, reasonable, and equally applied to all employees. 11.3.2. The norms of procedural and substantive fairness shall be applied and maintained in all disciplinary inquiries. 11.3.8. It is the responsibility of the HR and legal office to appoint an executive head, senior manager to chair disciplinary inquiry. 11.3.9. The alleged transgressor has the following right. The right to be informed of the nature of the offense, the right to be disciplined timeously, the right to be given adequate notice prior to the hearing and a copy of the notice to attend the disciplinary inquiry, the right to cross-examine witness, the right to state her case, the right to call witnesses, the right to a finding, the right to have previous service considered. Article 11.4.12 the human resources and the legal departments must ensure that the proceedings of the disciplinary discussions are recorded. 11.9.1, a formal disciplinary inquiry shall be scheduled when this transgression is of such a serious nature that dismissal may be warranted on court. In law, once parties of their own free will and volition enter into a written agreement, they should be in law bound to honor and be bound by the terms of their agreement, and therefore the relationship and subsequent disagreements must be resolved in accordance with their agreement, and the court cannot go outside the terms as agreed upon by the parties. It was held in the case of Ahmed and CBN that parties are bound by the terms of their contract, and the court cannot read into such contract what was not within the contemplation of the parties except where fraud, duress, or misrepresentation can be established. It is instructive to add that the terms of contract between the parties are clothed with some degree of sanctity. And if any question should arise with regards to the contract, the terms in any document which constitute the contract are arguably the guide to its interpretation. It's not within the purview of the court to write a contract for the parties. See the case of Minaj and Holdings Limited, Minaj Holdings Limited and Amcon. The courts, therefore, in determining whether there has been a breach of that contract, are enjoined to confine themselves to the plain words and meaning derived from the document. See the case of Oyamande and Abdulrahman. It's clear from the provisions of Exhibit 8, Clause 11 in general and Clause 11.9.1 in particular, that a formal disciplinary inquiry shall be scheduled in all disciplinary processes that will lead to the claimant's dismissal. Considering the above, therefore, claimant's relief, number one, is simply grantable. Claimant has contended in his second relief that his summary dismissal without the said formal disciplinary inquiry is wrongful. From the narrative facts of the claimant, she stated that she was issued a query on the 30th of 11/2020 and asked to respond to the same within 48 hours. That she submitted her detailed response on the 1st of December 2020. But on the 2nd of December 2020, a dismissal letter was issued to her. While the defendant, on the other hand, contended that by Exhibit JM8, it can summarily dismiss the claimant based on allegations raised without a formal hearing. But that notwithstanding, a disciplinary panel was even constituted and the claimant was invited on the day she was dismissed to discuss the query issued on the 30th day of November 2020 and the answer thereto. UW1 under cross-examination also stated as follows, and I quote, "It is correct that the claimant was issued a query on the 30th of November 2020, responded to the query on the 1st of December 2020, and she was invited to face the panel on the 2nd of December 2020, and the same panel sat on the said 2nd of December 2020 and dismissed the claim on the same date. By clause 2.5 of Exhibit INQ9, 3 days notice shall be given to appear before a disciplinary panel." Following from the above, I do not think that there was any formal inquiry constituted by the defendant for hearing of the claimant's case. I find it difficult to believe the defendant and the DW1 that the claimant was formally invited for any hearing. Exhibit INQ8 presented by the defendant to suggest that there was a hearing and or formal inquiry leaves much to be desired in many respects. Exhibit INQ8 is the purported minutes of meeting of the hearing of the claimant's case. It's clear from the exhibit that the meeting commenced at 5:21 p.m. on 2nd December 2020 with the claimant in attendance. Amazingly, the exhibit states that a termination letter was immediately handed over to the claimant at the meeting. I think this supports the submission or contention of the claimant that her dismissal was premeditated. The meeting, if at all it existed, was hasty, and the minutes appear to have been prepared just to justify the dismissal. But the law should not encourage and allow such kinds of practice. I have the firm belief that the entire hurried process of issuing a dismissal letter to the claimant a day after her response to the query is a breach of the defendant disciplinary procedure as contained in Exhibit 8 and appears obviously to be preemptive. In any event, I find that claimant's second and third reliefs should be allowed and are hereby granted. I need to underscore the fact that the most important aspect in any disciplinary hearing is that it must be conducted fairly according to the rules. To be able to do this, the employer is entitled to know the nature of the charge against him or her in order to be able to prepare for all his case. He or she should also be given the opportunity to state his case. He or she should be given the opportunity to state his or her case, no matter what circumstances are. It's not essential that she should be present in person throughout the hearing. See the case of Inchoe and UCTH. It's evident from the fact of this case there's nothing for this court to show that any notice prior to the purported hearing was given to the claimant. There is also no evidence of the proceedings of the disciplinary panel where the claimant and the persons in attendance or any other witness had any interface and interrogate each other. The claimant in her had any interface or interrogated each other. The claimant in her fourth and fifth reliefs has sought to ask that, having regard to the defense put up by her and her status as a senior manager, the outcome of the disciplinary process and the circumstances surrounding her dismissal are perverse, unreasonable, and unfair and demeaning. I need to observe here that the claimant prior to the query of 30/11/2020 was issued some queries which she responded. And in all her responses, she raised some issues that cannot just be brushed aside. However, instead of the defendant to consider a panel of inquiry with a view to investigate and deal with those issues, either way, according to the staff handbook, he just hurriedly issued a dismissal letter, making reference to the query of 30th November 2020, which was signed by DW1. This is what DW1 said under cross-examination. And I quote, the panel was consulted by the MD, and the MD and I were members of the panel. There was no other person apart from the MD and myself. I'm not aware as a lawyer that it is a breach of fair hearing to issue a query and still sit on a disciplinary panel for the same alleged misconduct. Yes, the MD or the chairman of the panel. Yes, by clause 11.3.8 of Exhibit INQ, the panel should be chaired by an executive head stroke senior manager. I don't know the meaning of perjury. We don't have a tape recording of the proceedings of the panel of inquiry, but we have the minutes. By clause 11.5.3 of Exhibit INQ3, the representative of HR and legal department should be present at all disciplinary discussions. I am aware that it is unlawful and unfair labor practice for a junior to sit on a panel over his superior. And I unquote, it is contended by the claimant that DW was a junior and the one who issued her the query of 30th November 2020, and still sat on the purported panel that led to her dismissal. I find that going by this, coupled with the evidence of DW1 under cross-examination, the outcome of the disciplinary process and the circumstances surrounding the dismissal of the claimant are perverse, unreasonable, unfair, and demeaning. Claimant's fourth and fifth reliefs ought to be granted, and I so do. For the substantive claim of redundancy pay, it is tried that a main claim and alternative relief cannot be granted at the same time. Where a claim is in the alternative, the court should first consider whether the principal or main claim ought to have succeeded. It's only after the court may have found that it could not for any reason grant the principal or main claim that it will then consider the alternative claim. In other words, an alternative award is an award that can be made instead of another. It's a separate claim and a separate award. It's not an additional award. Otherwise, it will amount to double compensation, which must be avoided. See the case of GK Investment Nigeria Limited and Nigeria Telecommunications. As for the claim for damages, the claimant in her remaining reliefs, save for cost and 21% interest, has asked for damages for wrongful dismissal, unfair labor practice, and breach of a fundamental human rights to dignity of human person. It was held in the case of Afolabi and Ola that general damages are only awarded where there is a breach. The law is settled that general damages are such that naturally flow the wrongful act of the defendant as claimed and established by the claimant, although it does not need to be specifically pleaded and proved like special damages. General damages are said to be implied or presumed from the proximate, direct, or immediate result of the act of the defendant that the claimant complied, and is normally granted at the discretion of the court, taking into consideration the peculiar circumstances of the case and guided by the judgment or standard of reasonable man. See Garaba and Ku, Ijebu, or the local government and Adedeji, Mobile Oil and Akim Fostile, Oyo State, and Fair Lakes Hotel Limited. In all the above cited cases, the principles governing award of damages, particularly general damages, were clearly enunciated that, and I quote, damages are compensation in money. There is a sum of money given to a successful claimant for loss or harm of any kind. Considering the above, and bearing in mind the fact and circumstances of this case, particularly that the dismissal of the claimant was declared wrongful and in breach of the defendant's handbook and disciplinary policy, the claimant is entitled to damages having worked for 21 years for the defendant. By virtue of Section 19D, the National Industrial Court Act 2006, it is provided thus, and I quote, the court may in all other cases and where necessary make any appropriate order, including an award of compensation or damage in any circumstance contemplated by this act or any act of the National Assembly dealing with any matter that the court has jurisdiction to hear. Unquote. On the whole, the claimant succeeds, and for the avoidance of doubt, I make the following declaration and orders. Number one, that by virtue of the defendant's handbook, exhibit JMA, it is declared that the disciplinary process leading to dismissal of the claimant must undergo a formal disciplinary hearing and or inquiry. Number two, that summary dismissal of the claimant, the defendant is declared wrongful for failure to comply with the defendant's handbook. Number three, that the defendant shall pay the claimant 6 months' salary as damages for wrongful dismissal, which stands at 14,253,000, going by exhibit JM12, which contains the consolidated salary of the claimant per annum in 2019 at 28,506. The alternative reliefs are hereby declined. Judgment sum shall attract 10% interest per annum until it is fully liquidated.
Ask for please.
Aja, you're around.
I'm around, my lord.
You're welcome.
Thank you, sir. You were on the road when I got the message.
It's okay. It's okay.
Well done, sir.
Thank you.
Yes, sir.
Yes, Adepate.
Yes, my lord, we are very grateful for the judgment.
Thank you.
Thank you, my lord.
Mr. Yoha.
My lord, we are grateful for the judgment. I just wanted a little bit of clarification because the internet connection broke at the point. You said 6 months salary at the sum of, I got 14 million, but I didn't get the other.
6 months, 6 months.
Yes, you mentioned the particular sum, 14 million something, but I didn't get the other one.
Yes, if you look at there is exhibit JM12, which was the last, salary given to the claimant per annum.
Yes, my lord.
It contains 28,506,06. So the 6 months would be half of that.
Okay.
Consolidated. Yes.
Okay.
Yes,
Fully
you got
understood.
it.
Yes, my lord, I do. Thank you very much for the judgment.
Yes, the exhibit contains her consolidated salary per annum, and you're not going to pay her half of
that. Yes.
Yes. And if you want to give her more, you can still give her.
Instead of giving her, they should give me.
Okay. And Mr. Yoha.
Yes, my lord.
It attracts 10% interest until it's fully paid.
10% per annum. Yes, my lord.
Yes. Per annum.
Yes,
Apologies, my lord. Is it 21% interest per annum or 10% interest?
No, 10.
10%. Okay. Very well, my lord.
Thank you.
My lord, we're very grateful.
Thank you.
Thank you very much, my lord. We are grateful.
Thank you, Mr. Yoha Adepate. Haja, is there any other thing?
No, nothing again, my lord. That's the only matter we have for today.
Okay, so in the absence of any other thing, I thank you so much, Adepate and Mr. Yoha. You are going to get the judgment next week, God willing, from Haja.
Thank you, my lord.
Very well, my lord.
Thank you. I'm very grateful, my lord.
It's okay. Bye-bye. Thank you. See you next time.
Yeah.
Thank you.
Okay. Bye, my lord.
Oh, no.